A Fox News alert breaking right now at Columbia University. Protesters have stormed and taken over an academic building on campus called Hamilton Hall. They're smashing windows, forming an actual barricade inside. There were also some reports of some workers at Columbia saying they felt they were being held hostage by these protesters inside the building. Constitutional attorney Mark Smith joins us now to talk about the criminal and legal aspects to all of this. So, Mark, beyond university discipline, what laws have these individuals, these protesters, broken by doing what they're doing, what we've reported so far, what you've seen?
Well, of course, it all depends, Todd, but the reality is the First Amendment right to free speech does not allow you to break the law. In other words, you can still be subject to violating criminal laws such as trespass if you enter onto private or public property that you're not allowed to be in. Also, if you destroy private or public property, you can be held liable for destroying property. And of course, if you assault someone physically, you're not allowed to do that. So exercising your right to protest, exercising your right to free speech, that's fine. But there's a famous saying, Todd, by former Supreme Court Justice Oliver Wendell Holmes that says, my right to swing my fist stops at the end of your nose. So free speech and protest is one thing, but if you start destroying property, assaulting people, breaking and entering, now you're into a whole different world.
Yeah, they're called time, place, and manner restrictions on the free speech right, but this is well beyond that. I mean, this is clear illegality. Columbia University is a private campus, really calling into question the notion of free speech to begin with. You know, if you're in a private setting, your speech, let's face it, can be controlled, but we are so far well beyond that. If, and this is a big if, especially in a city like New York, if the New York District Attorney actually decides to charge these people, what are we looking at here? Are we looking at misdemeanors? Are we looking at felonies? Are we looking at something that could put these people in jail for some significant amount of time?
Well, the first thing I would say, Todd, is it depends on what Columbia University wants, because if there is a victim, presumably it would be Columbia University. And you raise an excellent point that the First Amendment, as a general rule, only applies to government actors. Columbia University is a private institution. They're not the government. So arguably speaking, the First Amendment really doesn't play a role here because they're a private institution. But you're absolutely right. To the extent that Columbia University believes that their property has been destroyed, that their employees have been violated in some illegal way, well, then Columbia University can file a criminal complaint with the district attorney, and the district attorney and the police can take actions as if this were any other situation where you arrest the alleged perpetrators, you bring them into court, you let them plead guilty or not guilty, and you take it there. And then, of course, the district attorney can decide whether or not to plea out the case or pursue the case or not pursue the case. But certainly, if you look at what happened on January 6th with the federal government and the Department of Justice, they were very aggressive in using videotape to identify who did what when. The question is, would the district attorney and the NYPD and Columbia University have the same approach, or would they have a different approach here with respect to these protesters and these people doing what they're doing right now?
Yeah, the ignorance of these protesters is put on display, I think, in two striking examples. One, they don't know what the First Amendment is or in what situations it applies. And many of them, Mark, don't even know what Palestinian Authority is, what Palestine, or what they define as Palestine is, or where it is for that matter, besides the obvious ignorance of ruining your future if you are a student, getting suspended, and, you know, all your hard work and effort up until this point going to naught. Want to switch gears. I asked Allison Esposito before whether she thought the National Guard should be brought in. She said at this point, no, because the NYPD is able to handle situations like this. And that's fine. My question to you is not should the National Guard be brought in, but what's the legal standard that a governor or a president or somebody uses when they say, this situation I think has gotten out of control, we need the National Guard to rein it in? What's that legal standard? What's the approach that these individuals making these decisions have to take?
Well, I think we recently saw this, Todd, in New York City, where New York Governor Kathy Hochul decided to call in the National Guard from New York and deploy them throughout the New York City subways because of a rampant crime wave that was going on there. So certainly the governor would have authority to deploy the New York National Guard if if she felt that was appropriate. There are instances where the president can get involved, but I'm not sure we're at that kind of level at all right now. Really, this to me at this moment, Todd, is really a local law enforcement issue in conjunction with Columbia University, because at the end of the day, if there is a victim here, if there is a crime and there is a victim, it arguably is Columbia University and their staff. So the first step is, what is Columbia University going to do? For example, if Columbia University says, we're fine with them taking over these buildings, we're fine with them hanging out here, we're fine with them if they want to stick around all summer and just live in these buildings, well, you don't have then you don't even have trespass, because they've been invited in and they're now there with the consent of the owner. As to whether or not that's what Columbia University is going to do here, I don't know. I know what I would do, which is I would want them to be kicked out of my private property, and I would want them out of my institution, because they're not following the rules of the First Amendment. They're going far beyond that, Todd. But as to what Columbia University does, that is hard to say.
One more on this, Mark. As a parent now, I view everything through the lens of a parent. So my kids are nowhere near university age, but I'm thinking to myself, if they were in this situation, how horrific it would be for them just trying to study for final exams. So, question for you. Do students at this university who are basically being deprived of an education right now, who are being deprived of what their parents and maybe they have been paying for, do they have a cause of action against the school for allowing this to go this far? And do they have a cause of action, Mark, against the protesters to the extent that we can identify them?
Well, of course, you really can't have a cause of action if you have not suffered damages. So the question would be, Todd, is whether or not any of these students have suffered damages. Now, if they're able to take their exams and they're able to get their transcripts and they're able to move forward with their college degrees, well, it's not clear they would have suffered any damages. Certainly, they will have suffered annoyances to the extent that people are making noise outside their dorm room at 4 in the morning. That would certainly violate even the basic First Amendment time, manner, and place restrictions, which is I have the right to speak my mind. But I don't have a right to speak my mind at 3 in the morning outside your home with a bullhorn and keep you up all night. So, yeah, I think it would be a stretch to say they'd have a cause of action, because they probably don't have any damages. But certainly if someone is pushed or something bad happens to them, yeah, there's possibly a cause of action. But at the end of the day, I think proving damages would be the hard part of that. And I would just say one additional thing, Todd. Colleges are supposed to be places of learning. Well, if there's students participating in this and they get in trouble with the criminal justice system by virtue of their conduct, I think that will be a very important life lesson for them to learn that, free speech sometimes, at least the consequences thereof, is not always free.
An important point to make that these students clearly do not seem to understand. Want to get your thoughts, obviously, on the other big thing happening in New York City today, the New York versus Trump trial continuing this morning with more witness testimony. Second hearing day, a hearing day set for Thursday on the gag order. Let's focus on the testimony. Whether it's Pecker last week or Gary Farrow for this week, isn't this all an attempt by the prosecution to really set up and establish the foundation for the Michael testimony that is sure to be the barn burner in this case?
Yeah, the way to understand trials is they really are a version of storytelling. The district attorney has a particular story to tell. The defense has a particular story to tell. So what we've seen so far, Todd, is that the district attorney is trying to set the stage for the main actors, and that's why we're seeing the testimony of David Pecker here about the catch and kill program that they allegedly had. Now we're seeing testimony from bankers about the financial transactions here. And keep in mind, a big part of what's going on here is the district attorney's theory is that there was a reality of these financial transactions, and the reality of what these transactions were for and what they meant and how the money was used was different in some way than what was recorded in the financial records, in the bookkeeping records. So they have to show there's a difference between the realities of the financial transaction on the one hand against the record keeping of those transactions on the other hand, to show there's a disconnect or some falsity. That's the whole premise here. And then, of course, they have to argue at some point the consequences of that and the intent behind all that. And presumably that's what a witness like a Michael Cohen might conceivably be testifying about. We don't know until he takes the stand. But right now, I think that the district attorney is trying to set the stage. And at some point, they have to bring in the main actors to explain why this is is problematic under the law.
But I also think they know that those main actors, specifically Michael Cohen, are going to get annihilated on cross-examination by Trump's defense team. And so they were setting it up early with what I consider to be a pretty sympathetic witness, somewhat, in David Pecker. You know, nobody was going after him on either side. There were some attempts to attack his memory of certain situations, but generally, I think the prosecution did what it wanted to do, setting the stage before all hell breaks loose when Michael Cohen takes the stand. Mark Smith, thank you for jumping in with us on the Columbia protest. We appreciate it, and the Trump stuff as well.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.